So the Madhya Pradesh High Court on Thursday, 28th January, has rejected the bail plea filed by comedian Munawar Faruqui, as well as his associate Nalin Yadav, who was the organizer of the comedy show for which Faruqui and his friends are in trouble. Now, as you remember, on 1st January, Faruqui was detained by the Indore police and then arrested a day later based on the complaint by one Eklavya Gaur, who was the son of a local BJP MLA in Indore, and also has his own sort of Hindutva outfit called the Hindu Rakshaks. Now, they claim that Faruqui was making derogatory jokes about Hindu gods and goddesses, and therefore this was a violation of Section 295A of the Indian Penal Code, which is sort of meant to deal with intentional attempts to outrage the religious feelings of a particular community. Now, that's what the police have also ended up booking Faruqui and his friends under. They've been in jail now since 1st January. It's been 27 days. Attempts to go to the lower courts to get bail had failed. The High Court was now hearing this plea. And there were arguments raised on 25th January by Senior Advocate Vivek Tankha for Munawar Faruqui, where he pointed out that there had been no jokes actually made. There are many people from the audience who were saying that even before he'd got to make his jokes, the complainant had come and stopped him. There's statements now even from the police to the media that actually there is no recording of the incident itself. Now, in the backdrop of all this, we get this order by the judge, by Justice Rohit Arya of the Madhya Pradesh High Court, rejecting bail. And the key point which he makes is that he says, the evidence/material collected so far suggests that in an organized public show under the garb of stand-up comedy and commercial lines, prima facie, scurrilous, disparaging utterances, outraging religious feelings of a class of citizens of India with deliberate intent were made by the applicant. What the judge is basically saying is that the evidence and the material presented by the police to him is as part of the case diary, the witness statements, some supposed video footage as well, all of this indicate that there was some sort of offense committed here. Now, this is a tricky thing because if we look at what the judge actually cites as evidence, there are a lot of questions to ask. So first off, he talks about the fact that there are several statements by the complainant, Eklavya Gaur, by another friend of his, one Kunal, and several other people. But in particular, the judge singles out Eklavya Gaur and Kunal's statements. Now, what's interesting is that while Eklavya Gaur says that Faruqui got up, he started his show, he started making these jokes about Hindu gods and goddesses, and this was outraging people's feelings. Kunal's statement actually says something quite different. Kunal's statement says that actually what they heard was while they were waiting outside and then were waiting to go in, they heard Faruqi's rehearsal and his practicing of his jokes. And it's on that basis that they felt outraged and therefore decided to file the complaint. And that is what he heard. Now, so what you can see is already within the two statements which the judge himself cites as the key witness statements here, there is a fundamental discrepancy. Beyond that, the judge says that there's now video footage of what happened. However, the only video footage appears to be what was taken by Eklavya Gaur. At the same time, what many people have already said is that who have already spoken to the media, even the police themselves have admitted to the media that there is no video footage of the actual show itself. So what exactly is this footage which the judge is speaking of? Now, in fact, he even mentions that it's 32 GB worth of recordings, which sounds a bit strange because if the show was interrupted early on, it's difficult to see how that level of how that quantity of data would have been collected. Leaving all of this aside, there is also a simple fact that if you look at the statement by Eklavya Gaur, what he's talking about are jokes which Faruqui has already cracked in the past. And this is something which the judge again also points out. The judge notes that there's been a reference to the jokes which Faruqui has made for the last 18 months. And at the same time, he's holding that against Faruqui while rejecting bail, even though this case does not deal with those other cases, with those other jokes. It's not meant to be about that. So some very, very strange things in this order. There's also a particular line where trying to deal with the argument that Faruqui had not even got to make any of these jokes. The judge says, at this stage, it is difficult to countenance the submissions of the learned counsel for the applicant as complacency of the applicant cannot be ruled out, besides vulnerability of its acts in public domain. Now, it is unclear in what legal term the judge is referring to here because complacency of an accused is nothing. And this isn't just a typo. He uses the same terminology later to say that complacency of other people may also be here. So we're not clear what language the judge is using. This is not legal language. It's not English language either. And it doesn't seem to make a lot of sense. Finally, one of the other confusing aspects of this order, one which doesn't specifically deal with the rejection of bail, but which is concerning, is a whole set of paragraphs by the judge about constitutional duties to maintain harmony, etc., etc. Now, these are all very sort of laudable sentiments, but when it comes to a bail order, these are not relevant at all. Now, the judge hasn't included them in the operative part of the order, but at the same time, there's this whole discussion on aspects of Article 51A of the Constitution, which deals with fundamental duties. But that is entirely irrelevant to a question of bail, because neither are those duties legally enforceable, nor are they grounds for restrictions on fundamental rights. Now, you do have restrictions on the fundamental right to freedom of speech and on personal liberty, which are different, but they do not fall within the fundamental duties. So a very, very concerning order by this judge. There were already causes for concern, because the judge on Monday, 25th January, had in fact made several concerning comments during the very brief hearing he'd conducted for this. He barely took any oral arguments from Munawar Faruqui's lawyers, and instead made comments about how people like this should not be spared, and how one cannot afford to ever hurt religious sentiments. And so for all these reasons, there's a lot of concerns about this bail order, and it'll be interesting to see what happens when this gets challenged in the Supreme Court.